Thank you very much, Doug. So I'm dressed down for this occasion. I have my jacket over there, and compared to the formality of court, I am way dressed down. What I thought I would do tonight, though, is try and deal with some aspects of the story. Can everyone hear? Aspects of the story that are quite significant, because there's quite a linkage between the case that was lost and the battle that you're being asked to join in Parliament. But I want to put a few more ingredients in front of you on just the significance, the legal significance of that. And the most important thing I can say to you is that what is happening right now with the Navigable Waters Protection Act is radical. The government is behaving radically. The right of navigation, as described by Doug, is not an 1882 invention. It is described by all of the courts in the English-speaking world as an ancient right derived from Roman law. Just ponder that. And most interestingly, if you go south of the border or across the ocean, where our law derives on the English side, you will find one further addition to the legal terminology that has not yet occurred here today, and I'm going to encourage you to start using it. Under English law, navigation is not just a public right, it is a matter of public trust. English law has a public trust doctrine. American law has a public trust doctrine. Their courts hold government to account for breaching public trust. So navigation is not just a matter of saying we have something we are trying to do. It's a matter of throwing back at the very governments that are trying to do something a reminder that this kind of resource, our waters, are a matter of public trust that they are breaching. That is a very significant addition, in my view, to what the debate needs to say. And I'm going to give it in very concrete terms. What you want to say about the Navigable Waters Protection Act as you seek to reopen it, and this crazy little debate about minor, is you want to see a preamble, an opening, an introduction to that statute that describes the public trust in navigation across Canada. That will tell a story that is in keeping with the law from the South and from Great Britain, from Roman times, that's in keeping with where you are today with the use of the rivers and where the government is in complete ignorance. So that's point one. In this debate so far, at a political level, it is the government that is acting in complete ignorance of its traditions. Point two, when you go off to court, you may think that the court's job, which is to uphold the law, will follow those legal traditions. And government is so confident of that that when it gets decisions, it always says, well, the law has been applied. So if you go around to the present government to talk about the Kipawa decision, the law has been applied. And I'm here to say something very different. In that court case, that judge did not refer to a single case on his view of what navigation meant. Zero. He invented navigation law because there is not navigation law that supports the kind of things he was saying. So what have we done on the appeal? We've made front and center a reminder to the Federal Court of Appeal what navigation law is. And just without getting into the detail, our factum is referencing well over 20 decisions over the past century to support what we're talking about. There is nothing on the other side. Complete vacuum. So we have as a point one here, a failure of political parties, of political actors, of bureaucrats who you, Doug, very respectfully called public servants, not saying anything about public trust. Point two, off to the courts, when we're all supposed to defer to the courts about what they do in respect for tradition, we have a decision of the court that is in complete ignorance of all the law of centuries. That is why I, reading all this, took this on. This is important. We have to be able to respect our traditions and build on them. It's not a matter of simply, and I really have to say how much I enjoyed Jim Coffey's presentation to you, because it's not just a matter of protect and leave alone, it's protect and use sustainably, and that's the message he's giving. The difference between that and what's going on here is it's not a matter of protecting, it's not even a matter of using sustainably, it's zero standards whatsoever. That's what's at stake with the amendments that are being talked about. Zero standards whatsoever that relate to protection or proper use. Zero. So I'm going to stand down very quickly because my third point is you now have some ammunition. I'm going to go trotting off to court and have fun with the federal court talking about what cases mean. That's nice. It's very technical. I'll go do it and I'll look more formal than this and we can leave that. But what you need to go do is you need to now say it's not just a nice thing to talk about, the public right of navigation. It's what government is doing to breach the public trust we give government to manage things for our heritage. What was our heritage, what our future heritage is, that's what this is all about. Use the word public trust. And then, by the way, the fascinating aspect of this Kipawa thing is, what department of the federal government is supposedly managing this against us? The Department of Public Works. For whose benefit is the Department of Public Works, if not the public? And all across this, I'm just saying to you, the misuse of the word public is rampant. So your vocabulary going forward politically has to be to assert the public issues that are not being covered. Thank you very much.